This is the Mobile Home Park Lawyer Podcast with Ferd. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd.
Welcome back, Mobile Home Park Nation. Here again today talking about our closing documents for the close of the year. In our last episode, we covered a bill of sale and why that's important for the purchase of mobile homes, especially when you're buying them with the park, especially if you're buying them in a larger group as opposed to a one-off from a seller in town. This is from buying it from a park. Next, we're going to go talk about kind of a companion document, and this is your assignment of leases and assumption agreement. This is different than an assignment of a purchase contract, like when you're wholesaling to try to get a fee. The assignment of leases is really important because it's basically when the lessor, the seller, the landowner, and sometimes the homeowner, if you're buying park-owned homes, so you really need to make sure you get either a single double-purpose assignment of leases or get two separate assignment of leases. This is when you're making sure you're getting all of the rights as landlord. These are things like rights to back rent, rights to possession of the homes or possessions of the land, rights to enforce the rules, blah, blah, blah. This is just really important. If you get into disputes, this is important for indemnification provisions and purposes because there's a fixed date and time, typically simultaneous to closing, where if the previous guy didn't rent to somebody because they were white, black, or purple, I can say, look, that's not my problem. I didn't do that. This was 2 days before closing or 3 weeks before closing. Don't come after me. I can prove that I was not the lessor and this guy indemnified me. Go sue him. And really, it just also helps for tax purposes. If you're going to forgive back rent, it's going to help for eviction purposes. You have the rights of standing. And then also, you under the lease, you have the ability to modify lease, let people out of leases early, enforce rules, fines, etc. So, assignment of leases is an important closing document. You got to make sure you have this. Much of it is boilerplate. At the beginning, it's the typical whereas clauses, the name of the lessor, which in this document is typically called the assignor, the name of the assignee, the date. It's got the history of the real estate contract, the simultaneous asset purchase of the personal property, if there is any, which is the park-owned home bill of sale. And then just the standard assignee wishes to assume the rights, title, interest, and obligations. Assignor wishes to transfer the same. Those are called the recitals. And then there's a formal phrase of acceptance and assumption of risk. But as the buyer, the new lessor, in this document, the assignee, what you really want is the assignor to represent. And that's a big deal in real estate, representations and warranties. They want to represent and warrant that the lot leases listed on Exhibit B are the only ones. You want to make sure there's not any hidden leases. You want to make sure you have true and complete copies of the leases, if any, including all amendments, addendums, extensions, exhibits. There too. There are no oral modifications, that the assignor has performed all obligations under the lease, that the assignor is not in default on any of the leases, that there's currently no litigation pending related to them, that the assignor has not assigned its interest to another person or entity, that no person or entity has a right to use any portion of the real property for free or at a rental rate. Sometimes this kind of stuff, by the way, is accepted, and as long as you know, like I recently worked on a case where there was 3 or 4 siblings that owned this property together in an LLC, and the one brother had been living on the property and helping mom and dad run it for 50 years. And he was, 75 years old. And it was a sticking point of the deal that he got to have what's called a life estate, which basically means he got to live there lot rent free until he died. And, he could have lived for another 30 years, but realistically, he probably won't live for 10 more years. So my client, who was the buyer, basically had to factor in, okay, if that's $300 times 12 months times 10 years, okay, that's $36,000. This guy going to live that long, and you need to take that into pricing consideration. I don't know if that's ever been a deal breaker, for anybody, but there is an economic impact to that kind of term. So in this case, that provision that no one has free or discount rental rate, that would not have been accurate. So they would have struck that in a red line. And then really the next representation is that all tenants are performing their lease obligations as required. Again, unless there's an exception. So we typically do is we ask for a certified rent roll every month due diligence in at the day of closing. And that's used for prorations on the closing statement. And I'll go through closing statements here in another episode. But it's good for prorations, and it's also helpful. The certified rent roll allows you to track security deposits and the transfer of those, which also is included as part of the assignment of leases. And also, typically, the buyer, this is my bias, the buyer gets the rights to any back rent and future rent. Now, that's distinct for the month of closing. So, like right now, as I record this, is December 21. If I were to close today, if the seller has not collected December rent, we could do one of two things on the assignment lease. The seller could get credit for December rent, in which case I get my last 10 days. But if the seller has not collected it, they're going to say, hey, if you later collect, I want to be reimbursed, because they basically already gave me 10 days that I was already paid for, and I would be double dipping. So I got to pay them the 21 days worth. And the other way of doing it would just be to say, hey, the seller did not get the December rent, so they don't give me any of it. And now I got a receivable for the first 21 days and the last 10 days. As the buyer, I don't want to really unjustly enrich the seller for not doing their job of collecting rent. Now, if this was on the 2nd, it's a little different. This is generally not, the month of closing is generally not a big one to fight over, because there's probably a pretty good expectation that it'll be collected if the history is good. If you've got somebody that's 11 months behind, there's no way the seller should get credit for 11 months. So typically, the buyer gets credit to that back rent. But I want to make sure that's crystal clear in my assignment of leases, because what I don't want is the day after I buy, the seller's out there shaking down my tenants or garnishing their pay or something like that. Realistically, they don't have a big stick because they can't take the home anymore. They can't evict them for possession. But I don't want them shaking down my tenants. This is not as big a deal in the mobile home park space, because if they haven't paid, they're probably not going to pay back rent. And as a buyer, you can maybe get them to just try to get current and start paying future rent. That usually works okay if you just say, I'll forgive the 5 years. I've literally bought parks where there's 5 years of back rent. And say, I'm not going to ever get the 5 years worth out of you. But I've had some people pay 6 months worth, and then I've had people just start getting caught up. So that's really important. When I used to do retail, I had, I think it was CVS, man. They were behind like 2.5 years on taxes somehow. And it was just the other landlord wasn't making them pay it. It was a substantial number, like $57,000 or something. And we didn't put up with that. We're just like, you need to pay us or we're evicting you. And they're like, okay, fine. And they paid. But for a minute there, it was like, why the heck is this a problem? Are they going to go belly up? No, they were just for being stubborn, so to speak. But in mobile, they had the ability to pay. They just weren't. And this wasn't their base rent. This was what's called triple nets, and this is their taxes, which I won't get into any more of a tangent than I already have. Not really a big deal in MHP, but you still want to get the back rent and future rents. This document also has a mutual indemnification provision that I mentioned. I'd like to be mutual. That generally makes the seller more comfortable, and it makes sense, right? It's good for the goose, good for the gander. And you typically will also have a successors and assign provision, which basically says it inures to the benefit of the successors. I mean, if I die the day before closing or the day after closing, my entity or my successor in interest gets the benefit of this. Sometimes you have the standard execution and counterparts, the cost of enforcement, jurisdiction, those kind of standard legalese phrases that nobody ever reads, let's be honest. And then you got your signature blocks, assigner, assignee, your Exhibit A with the legal description, your Exhibit B, and that's where you list the actual lot leases. And typically it's the lot number, the resident name, the lot rent, the security deposit, if there's any back due balance. And then I typically put another little provision at the bottom that basically is a catch-all, like, assignor, as lessor certifies the above rent will be accurate as of the day of closing. And the assignor as lessor has not provided assignee with any written leases for the property. And that's the template I'm looking at, has not provided written leases, which was the case in one of these that I did recently. But if they are written, you want it to say, assignor has provided all copies of written leases, and there are no others other than set forth above. This one I'm looking at here was recent where the guy's like, I don't have written leases. It's handshake. So I'm like, well, I want you to at least sign off so that nobody comes out of the woodwork day after closing and says they got a 10-year dollar per year lease. So anyway, important closing document. I feel like this gets missed, to be honest, in like half the projects I work on. Not the ones I work on, but they would be, I guess, where I tell the seller, hey, look, I got a draft assignment of leases, and they're like, what is that? And this is sometimes even like professional buyers that have owned the property for 2 or 3 years. They just, I don't know, for some reason this isn't that popular. It's a really easy document. I mean, it takes, I don't know, half an hour for me to prepare one. I don't know why people don't do this. It's not that complicated. If you play this like 3 times, you probably can just plagiarize my entire document. but don't do that. That might be illegal. I don't even think it's legal, actually. It's probably not. Frankly, I don't care. That's what I'm here for, education. I'm not looking for your 30-minute gig. But anyway, make sure you do it right. That's part of the purpose here, right, is educate people to do this right. Get your bill of sale right, your assignment of leases, your warranty deed, your owner's affidavit, your title policy, your loan docs, like your promissory note, your assignment of rents, your deed of trust, your mortgage, those sort of things. We'll go over some of those when we get time, but for today, just make sure you get the assignment of leases right. Till next time, God bless. Merry Christmas.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.